Good evening, ladies and gentlemen. Welcome to tonight's debate. My name is Jim Dunlop, and I practice law here in Chicago, but I'm speaking to you tonight as a board member of the Chicago chapter of the Federalist Society for Law and Public Policy Studies. Our national organization, the Federalist Society, is a co-sponsor of this evening's debate, as is our local chapter. Before we begin, I'd like to thank four people without whose efforts tonight's debate would not have been possible. The first is Mr. Jack Miller, whose personal philanthropy allows this evening's debate to take place, and whose foundation does wonderful work in promoting American principles in our colleges and universities. I would also like to thank Mr. Jeffrey Coleman, who is my colleague at the bar here in Chicago, and who secured for us tonight's moderator. I'm grateful to Robin Wagner of DePaul University College of Law for securing our wonderful venue, the Pritzker Military Library, and for performing the many associated tasks in connection with that. And I thank Maggie Coles from my own organization, who kept track of the torrent of RSVPs for tonight's event. We're fortunate to have an array of distinguished organizations co-sponsoring tonight's event. In addition to the Federalist Society, we have the American Constitutional Society and the Constitution Project. All three are dedicated to promoting a better understanding of the U.S. Constitution in the place of law and the judiciary in our society, each from the point of view of their own members. We are also pleased to have as a co-sponsor the Jack Miller Center for the Teaching of American Founding Principles and History, which supports undergraduate education to ensure that students receive not only a thorough grounding in American political theory and history, but an appreciation of its genius as well. One of Chicago's most venerable institutions, DePaul University College of Law, is also a co-sponsor of tonight's debate and brings us its special dedication to the teaching of international and comparative law and human rights law. And we are pleased to have Ricochet, a public policy news feed and discussion forum, as a co-sponsor and a webcaster of tonight's debate. Together, our co-sponsors form an ideologically diverse array of organizations that together represent the full spectrum of thought and opinion on tonight's topic. This coming together among them to sponsor tonight's debate is, for each of them, a patriotic gesture. Each of them is vitally concerned about our country's safety and security, and each of them is equally committed to preserving its liberties. And in joining together to present this debate, they represent our country's virtue. Our debaters tonight are John Yoo and Alberto Coll. And our moderator is Jim Warren. Jim Warren is the former managing editor of the Chicago Tribune. And before that, he was Washington bureau chief. He co-founded the Chicago News Cooperative. You can read his insightful and penetrating writing on Fridays and on Sundays in the New York Times, where he is the anchor columnist for Chicago. And Jim also contributes to the Public Square with his columns in the Atlantic and other publications. Please join me in a warm welcome for John Yoo, professor of law at the University of California at Berkeley, Alberto Coll, professor of law at DePaul University College of Law, and Jim Warren, who will introduce tonight's topic, the speakers, and the format of the debate. Thank you. Okay.
Get to sit. Good evening, everyone. Downstairs, upstairs, overflow room, fabulous. Let me first start by thanking Jim Dunlop of Jones Day. Now, his labor in pulling off this event may not be quite like Bill Clinton getting Rabin and Arafat to shake hands on the White House lawn, but it doesn't fall a whole lot shorter. Fashioning the involvement of such ideologically diverse groups was a feat, but there also was just the grunge work, a lot of very practical matters which I was slightly privy to, and which go into any large-scale event. And I suspect the billable hours that he has surely set aside may well amount to a sum vaguely comparable to what Rahm Emanuel desperately needs to fill his yawning budget deficit. Second, let me exhibit a firm grasp of the obvious. We're gathered to discuss and hear these guys debate a very important topic, all the more so on this 10th anniversary week. How does one define the president's powers? and his war powers. It's not a phrase obviously found in the Constitution. Yeah, it says he's commander-in-chief. And presumably the power is absolute if the Congress passed a law saying he must, presumably the power is absolute if the Congress passes some wacky legislation saying that he must invade a country from the north or from the south, or only do it with small handguns or having everybody wear Cubs hats. But does it include rendition, torture, wiretapping domestically without warrants, or seizing an entire industry like steel? Do the Bush-era policies, including the prison at Guantanamo, constitute what one harsh critic calls a, quote, human rights debacle that will eventually take its place alongside other wartime misadventures, including the internment of Japanese Americans during World War II, the prosecutions under the Espionage and Seditions Act during World War I, and the suspension of habeas corpus during the Civil War? 3 quick points to finish. To me, when I thought about it, it's pretty reassuring on the subject of huge significance to our democracy that we have a debate between 2 immigrants to this nation whose professional accomplishments are really testament to our nation's core values. John came from South Korea when he was a mere tyke of 1 and was raised in and around Philadelphia and the New Jersey burbs. He attended Harvard, then Yale, served as counsel to the Senate Judiciary Committee, and has been on the faculty of Berkeley Law since '93. He's here tonight, quite obviously, because of issues he dealt with while at the Department of Justice between 2001 and 2003. He's written extensively about and in defense of the policies he successfully argued for within the administration of President Bush #2 and Vice President Cheney. Alberto grew up in Cuba and came at a much later stage of life at age 13 without his parents, whom he wouldn't see for 10 years, and without speaking a single word of English. His father spent 9 years as a political prisoner under Castro. He grew up with distant relatives and family friends in South Florida, attended Princeton. Remember, he got here at 13 without knowing a single word of English on a scholarship. Has taught at Georgetown, taught also and been dean of the Naval War College in gorgeous Newport, Rhode Island, and oversaw special operations forces and low-intensity conflict while in the Defense Department of President Bush #1. And one should note, while there, he was awarded the Medal for Outstanding Service by Defense Secretary Cheney. Since 2005, he's been here in Chicago doing an apparently bang-up job at DePaul Law School. Second, as far as the arguable catalyst for this gathering, I can hereby disclose it came on or somewhere near Hotel Treadmills in San Diego, where our protagonists were attending a conference on Thucydides and struck up a friendship. Now, I hesitate to draw any parallels between the Greek historian and the topic at hand, such as his view that relations among nations should be based on might, not right, that the Peloponnesian War was an event of unmatched significance, or that Athenian democracy was a pretty darn ambiguous matter. If these guys want to bring up Thucydides, be my guest. Finally, the format. Opening remarks of 12 minutes each. Then rebuttal, 8 minutes each, with about a minute. Well, no, we decided I'm going to like to do a Vanna White thing or something. With 5 minutes left, I got a little card I just made out. I'll put 5, and then with 2 minutes left, 2, and then when it's over, I'll get up and say next. After the rebuttals, it's question time. I may ask 1 or 2, depending on how I think things are going. And then we've got microphones downstairs, upstairs, and in an overflow room. So we'll probably start downstairs, go upstairs. Obviously, I can't see who's in the overflow room, but I'll ask for questions from up there. Housekeeping matters. Turn off your cell phones. And if you've got a drink with you, alcoholic, non-alcoholic, doesn't matter, could you please, when you split, don't just, some of us do at the theater with candy wrapper, just stick it under. Can you just take it out and put it on one of the tables that'll be outside when we're done tonight? Okay, so now we begin. The resolution resolved that the President's war powers are nearly absolute. opening statements, 12 minutes each. It's a great pleasure to introduce John Yoo.
Thank you. Thank you very much to Mr. Miller for his patronage of this event, the Federal Society, the American Constitution Society, and the Constitution Project for inviting me. And I'd like to thank my friend Alberto Coll for thinking of this idea to have this debate. Alberto and I were indeed working out at the gym. I'm ashamed to say that Alberto displayed more Spartan qualities at the treadmill than I like to think of myself as the poor Athenian who'd rather read, drink, and play around than work out at the military virtues like my Cuban Thucydides opponent here tonight. Also, I think this is a wonderful way to commemorate the 10th anniversary of the September 11th attacks by focusing on the core constitutional question I think we all would agree with, which is the extent of the president's power in wartime. That said, if any more specific questions about the war on terrorism or executive branch policy or congressional actions come up during the question and answer period, I'd be happy to answer them. So let me begin in the short time I have for opening statements to say, first, in terms of the statement, that already describes practice. And I think we're going to debate about whether practice actually is constitutional or not. But in terms of practice, the president already exercises the great bulk of the war power. Look at our recent fight about the war in Libya. In Libya, President Obama decided unilaterally to use force to try to overthrow the Gaddafi regime. Congress had an opportunity but never voted authorization or approval. Congress didn't even specifically vote to approve funding for the conflict. The Supreme Court and the lower federal courts never adjudicated a case. So in this respect, I agree with Judge Easterbrook in the previous panel who was getting the willies when he thought about all three branches getting involved. I think one of the implicit worries he was expressing was that the judiciary is the last one that should get involved. And when it comes to war powers, the judiciary has not been involved. The judiciary has never issued any kind of injunction trying to stop a war started by a president. And the Libyan war is not unusual in this respect. A number of wars going back, I would say, beyond the Korean War, which was also not approved by Congress, any kind of authorization or declared, but if you go back all the way to the Civil War, at the very least. We've had wars where presidents reacted to events, decide on the use of military force without any kind of pre-authorization by Congress. I think the real question is whether that's consistent with the text structure and history of the Constitution. I think there's a common myth that the Declare War Clause in Article 1, Section A of the Constitution requires that Congress pre-authorize every war, that there be essentially two keys to turn on the engine of war in our country, and that you need both Congress and the President to agree before hostilities start. I just don't think that the Declare War Clause bears that weight. If you look at the Constitution, Congress certainly has maybe the bulk of the war powers that we've given to our federal government, but almost all of them are in the areas of creating the military, funding the military, and issuing rules for its government. It would be strange, I think, if the framers wanted to say, and Congress gets to to decide whether we're going to go into hostilities beforehand by using the Declare War Clause. Right? There's no process set out in the Constitution like the one we have that's delicately given for the enactment of a statute, for example, that describes how the President and Congress are supposed to work out going to war. Instead, I would say the Constitution leaves the matter up in some doubt, and I would say it expects that the President and Congress will use the constitutional authorities they have to fight it out from war to war for the upper hand. And we have had periods in our history where Congress has been the dominant branch when it comes to wartime, and periods when the President has been the dominant branch. I'll turn to that in a second. But to me, if you look at the way the Constitution is written and structured, and at the way the branches have used their powers, the real check on the President's ability to take the country into war is the funding power and the power to create the military. If Congress doesn't want the President to go to war, if Congress doesn't want the President to have even the assets at his disposal to start hostilities, all it has to do is cut off the funds for the war or never even build the kind of military that the President wants in the first place. And in fact, I would say before 1945, that was a perfect check on the presidency because we really had no large standing military in this country. So if the President wanted to go to war, he would have to go to Congress and get them to build an army or a navy for that war. It's only after 1945, in this period where we've had an enormous standing army, that we've had this problem come up, I think, in this direct a way. But I don't think that we should ignore the fact that Congress has created a military that's designed for offensive operations. As I think we were unfortunately reminded on September 11th, there were very few military assets actually inside the United States devoted to the defense. If you look at the way that Congress has paid for and structured our military, we have a large military stationed in other people's countries designed to carry out offensive operations beyond our shores. It's not a military designed for homeland defense. That's not the president's doing. The president doesn't get to decide how to spend the money and how to build a military. That's up to Congress. At the same time, Congress never put limits on those funds or limits on those military units when they created it. So to me, the real check is going to be the political process and Congress fighting with the president using its power of appropriations and structuring and raising of the military. I think that's consistent not just with my reading of the Constitution, but with history. So let me take you back to the creation of the Constitution. Right? All the phrases in the Constitution in this area are borrowed from the British Constitution. In the 100 years before the American Constitution, the British and all of our framers were British, right? In that 100-year period, the King of Britain only declared war once before the British Empire entered into a war. In fact, it was the common practice to issue declarations of war afterwards, sometimes years afterwards, after hostilities would start. I think that means it would have been a very odd thing for the framers to have used the phrase declare war in our Constitution to refer to the power to start hostilities, because it had never meant that before. Second point about our early history is you'll commonly hear the argument, I'm not sure if Alberto is going to make this argument, you often hear the argument that in favor of a very pro-Congress approach, that our framers were against executive power. They rebelled against King George III. Therefore, you should never read the Constitution to actually create a strong executive. I think that represents an unsubtle reading of the history. It is true that our framers, does that mean minutes left or 5 more points I get to make?
We want to get home
I'm just
tonight,
kidding.
so 5 minutes.
So our framers, as revolutionaries, did rebel against King George III, and then created state constitutions that were ridiculously anti-executive, to the point where my home state of Pennsylvania had, instead of a single governor, had a 12-man council to be the governor, where everyone was only allowed to be on the council for 1 year and rotated off and could never be put on the council again. Right? It is clear that the revolutionaries were very hostile to executive power. But then, in that period between 1776 and 1787, our framers, particularly the Federalists, saw that that was a great mistake, that these experiments in legislative-dominated governments were a failure. And the thing that's actually quite remarkable is how close the Constitution comes to restoring executive power to the way it had been before the Revolution, although based on Republican principles and accountability rather than a hereditary monarchy. Right? The presidency is created as a single person. And as Alexander Hamilton said in the Federalist Papers, the reason for that is so that the presidency could act quickly and swiftly, particularly with regard to foreign relations. In fact, I would say the main purpose for the creation of the presidency was to take care of national security and foreign affairs and to put that power into one person. Although they were very aware of the dangers, obviously. They were close students of the classics in Roman and Greek history. They were concerned about the idea of monarchy or tyranny or adventurism abroad. Still, they made the choice to put that power in the hands of one person because it would allow the country to react swiftly and quickly to unforeseen events, unforeseen threats. So I think I just have a few minutes left. Let me just ask about the consequences of this arrangement. Right? So you could have a president-based system, the one I'm describing, where the president is the one that goes first in making decisions about war. The legislature has an ex post opportunity to ratify it or stop it using the funding power if it wants to. Or you could have a system based where Congress is the one who makes a decision first and the president carries it out, which is much more along the lines of what we have for domestic policy. And I would ask you, which one do you think actually will lead to better policy for the United States? I think there's this urban myth that allowing the president to decide first has led to more disasters for the country than letting Congress decide first. But I think that's because, as is natural amongst human beings, we tend to focus on mistakes of commission, when someone does something that turns out to be a mistake, and we forget to think about errors of omission, failures by inaction, by failing to do something. So we have examples like the Vietnam War and Iraq, which people will commonly refer to when they think of errors of presidential action, although I will add that all these errors that we usually talk about are ones where Congress did approve the war. Vietnam and the Iraq War and the Afghanistan War were all wars that don't raise this constitutional question because Congress did authorize those conflicts. But think about cases that we focus on less, where Congress is the one that's dominant, which has happened in periods in our history. Think about the period which Arthur Herman was referring to in his remarks earlier about the period leading up to World War II, where Congress was the dominant power and so handcuffed President Roosevelt that it took, I think, way too long for the United States to enter into World War II. And if we had been able to, and if he had been able to, not just the United States, but the world would have been better off. Or more recent cases like Rwanda, where President Clinton, I think, felt a great deal of reluctance to intervene. 1 million people lost their lives at the cost of maybe sending 10,000 troops to keep apart ethnic groups. But also, let me just say, and I'll close with this, Congress can also just as be equally aggressive and maybe more mistake-prone than presidents. I think the worst war in our history is not Iraq or Vietnam, but from a strategic perspective was the War of 1812. Think about that war. The great superpowers of the world, Britain or France, are fighting to the death in Europe. What does the United States do? We're making money like you wouldn't believe off the war. In fact, our trade doesn't return to that level until World War I. So what do? A new freshman Congress comes into office. They demand that we go to war with the only country that had a navy, right? The only country that had troops on our borders, Canada. Why? Because our pro-Congress, Congress-dominant political system then, these members of Congress wanted to invade Canada. For reasons, as an immigrant, as you said, for reasons that continue to escape me. I still don't understand the American fascination with taking over Canada, other than the desire to get universal health care that much faster.
I'll give you 5 more seconds.
5 more seconds. So my only point in that is that when we talk about constitutional design, we can have an argument about the legitimacy and the history, but also ask about the consequences. Is it really the case that having a Congress-dominant system where Congress has to approve conflict before it happens actually would lead to better results for American national security than the one we've had for at least the last century? Thank you very much.
Albert, thank you. Alberto Coll.
Ladies and gentlemen, it is a great honor for me to be here, and I too want to thank the very generous sponsors of this debate, the Jack Miller Center, the Federalist Society, the American Constitution Society, the Constitution Project, and the DePaul University College of Law. We're honored to have our new dean, Professor Greg Mark, with us this evening here. And it is a great honor to be debating Professor Yu, who is a thoughtful, learned scholar and a very honorable public servant. I have read John's book on war and peace after 9/11, The Powers of War and Peace, the Constitution and Foreign Affairs since 9/11. And much of what John just said to you, I don't have any problems with. But there is one major issue that I think is fundamental, that I find deeply, deeply troubling. And that is his argument in his book that the President of the United States has the constitutional authority to take this country into war without the Congress. And John's scholarly analysis in his book is very subtle, very sophisticated. There is one problem with it, and there's one problem with his reading of the Constitution, which is that all the people who wrote the Constitution and who lived at the time of the Constitution strongly would have disagreed with him. So my proposition here is that it is true, of course, the president under the Constitution has authority to respond if the United States is attacked. And it is true, as John says, that the founders wanted a strong executive, absolutely, a strong executive that would conduct our foreign policy with vigor and intelligence. But he goes too far in suggesting that under the constitutional scheme, the president on his own can take the country into war. And so I would like to read quotations and the writings of some of the people who were intimately involved in framing the Constitution and let you judge what you think about this argument. I want to start out by, first of all, saying that the power to declare war, which is very clearly given to Congress, okay, in his book, John argues that a declaration of war simply meant announcing to the world that the United States was at war and announcing that various legal obligations were triggered. And I want to suggest that while this was one of the functions of a declaration of war, there were two other functions of a declaration of war. It also meant moving and putting the country into war, and that only Congress, not the president, could do that. And implicitly, it also meant authorizing the country to enter into a war. Let me read from James Madison, who was intimately involved in, of course, the drafting of the Constitution. And in a series of letters that he wrote in 1793, where he called himself Helvidius, he talks about the president's commander-in-chief power. And this is a power that, of course, the president has. And many scholars who agree with John argue that the power of commander-in-chief includes not just the power to head the army and the navy in times of war, but also the power to make the decision to go to war. Here's what Madison wrote. He said, "Instead of being analogous to the power of declaring war, it affords a striking illustration of the incompatibility of the two powers in the same hands. Those who are to conduct a war, the president, cannot in the nature of things be proper or safe judges whether a war ought to be commenced. They are barred from the latter functions by a great principle in free government, analogous to that which separates the sword from the purse, or the power of executing from the power of enacting laws." In another letter written at the same year, that's 1793, he's got this very eloquent passage. "War is, in fact, the true nurse of executive aggrandizement." Here's Madison's warning to us. "In war, a physical force is to be created, and it is the executive will which is to direct it. In war, the public treasures are to be unlocked, and it is the executive hand which is to dispense them. In war, the honors and emoluments of office are to be multiplied. It is in the executive patronage under which they are to be enjoyed. It is in war, finally, that laurels are to be gathered, and it is the executive brow they are to encircle. Hence, it has grown into an axiom that the executive is the department of power most distinguished by its propensity to war. Hence, it is the practice of all states, in proportion as they are free, to disarm this propensity of its influence." And in a letter to Thomas Jefferson, 4 years later, he wrote, "The Constitution supposes what the history of all governments demonstrates, that the executive is the branch of power most interested in war and most prone to it. It has accordingly, with studied care, vested the question of war in the legislature." The question of war, not just declaring war, but the question of war. Alexander Hamilton, who of course was also intimately involved in the debates surrounding the Constitution, and who cannot be accused of being a critic of executive power. In fact, Hamilton wanted a strong president, a vigorous president. Here's what Hamilton wrote in the same debate with Madison under the name Pacificus. "The legislature alone can declare war, alone can actually transfer the nation from a state of peace to a state of hostility." So it's not just a matter of announcing to the world, we are at war now. Only can actually transfer the nation from a state of peace to a state of hostility. In the distribution of authority, the wisdom of our Constitution is manifested. It is the province and duty of the executive to preserve to the nation the blessings of peace. The legislature alone can interrupt them by placing the nation in a state of war. And then, in letters in which he called himself Lucius Crassus, they love the Romans, as John and I do, written around shortly after 1801, he wrote, "The Constitution has only provided affirmatively that the Congress shall have power to declare war, the plain meaning of which is that it is the peculiar and exclusive province of Congress when the nation is at peace to change that state into a state of war. In other words," he continues, "it belongs to Congress only to go to war." He doesn't say just to declare that there's a war going on. It belongs to Congress only to go to war. President Washington, 1793. "The Constitution vests the power of declaring war with Congress. Therefore, no offensive expedition of importance can be undertaken until after they have been deliberated on the subject and authorized such a measure." Thomas Jefferson, in a letter to Madison, very famous letter, 1789. "We have already given in example one effectual check to the dog of war by transferring the power of letting him loose from the executive to the legislative body." Chief Justice Marshall, Supreme Court of the United States, 1801. "The whole powers of war being by the Constitution of the United States vested in Congress, the acts of that body can alone be resorted to as our guides in this inquiry." Justice Story in 1833. Justice Story wrote the most significant commentary on the Constitution of the United States. He was a very close associate of Marshall on the Supreme Court, very close to that generation that carried out the revolution of the Constitution. And in his commentaries on the Constitution, he says, "The power of declaring war is not only the highest sovereign prerogative, it is in its own nature and effect so critical and calamitous that it requires the utmost deliberation and the successive review of all the councils of the nations. War in its best estate never fails to impose upon the people the most burdensome taxes and personal sufferings. It should therefore be difficult in a republic to declare war. The cooperation of all the branches of the legislative power ought, upon principle, to be required in this, the highest act of legislation." And then, of course, there are the famous words of Abraham Lincoln during the Mexican War that he opposed, 1845. "The provision of the Constitution giving the war-making power," notice the language he uses, the war-making power, "to Congress, was dictated, as I understand it, by the following reasons. Kings had always been involving and impoverishing their subjects in wars, pretending generally, if not always, that the good of the people was their object. This our constitutional convention understood to be the most oppressive of all kingly oppressions. And they resolved to so frame the Constitution," very important words, "that no one man should hold the power of bringing this oppression upon us." So, ultimately, the question comes, has the practice in the last 50 years in any way changed what the Constitution means? Now, this is a very difficult argument for my friend Professor Yu to make, because he insists that we should pay a great deal of attention to the original intent of the framers of the Constitution, a proposition with which I agree. But the problem with his argument is that everyone who lived around the time of the Constitution believed that Congress, and only Congress, had the power to move this country from a state of peace into a state of war. Now, it is true that in the last half a century, presidents often have tended to ignore this constitutional mandate. And the question I want to pose to you is, do we want to simply accept this record of usurpation, or as citizens and students of the problem, do we want to change it and bring it back to the rightful balance in which, yes, we have a strong president who conducts foreign policy, we have a strong president with the authority to respond to sudden attacks on this country, but when it comes to the question of putting the nation into a state of war, particularly in wars in which there is plenty of room for deliberation, in which there is plenty of time to consider the matter, shouldn't the people's representatives be the ones who deliberate and make that decision, and shouldn't the president be bound to that as his predecessors were
Give you 5
earlier?
seconds if you want.
That's it.
Finished here? We're now going to do, thank you. We're going to do 8 minutes each, and if it's okay with you guys, why don't I just use my Vanna White number 2 card to give you a 2-minute warning? How about that?
Okay, first I'd like to say that Alberto has tricked me, because here he is, this wonderful, warm, Thucydides-like figure inviting me to debate, and he does the nasty trick of reading my book and then quoting things out of it against me. Dastardly, I'd say. But I very much appreciate his comments. I think at some part we may have a disagreement about how best to understand the original meaning of the Constitution. It sounds like we share the idea that we should look back to what the framers thought when they ratified the Constitution. Unfortunately, I think a lot of the quotations that Alberto has given are not from that period. So I take very seriously the arguments of James Madison and Alexander Hamilton, but these arguments that he's made are from 1793. Right? They are not presented in 1787 or 1788 at the time that our framers drafted the Constitution and ratified it. And if you go back and look at the debates, that's why, unfortunately, that book is very long and so was unbought and unsold and unread, is that I tried to go through in great detail, what did people actually say when they had the Constitution before them? There was a great debate on this issue that we're talking about in that period, in the ratification debates in the state of Virginia, which was the key state for ratification of the Constitution. Right? If Virginia had not joined the Constitution, we would have had no presidents for the first 4 or 5 terms. Virginia also only ratified the Constitution by, I think it was 188 to 180. So it was extremely close. And many of the best framers were present at that convention. One of them, who was against the Constitution, was Patrick Henry. Patrick Henry was the leading voice against ratifying the Constitution. Remember, Patrick Henry is the one who said, "Give me liberty and give me death," and after about 10 years of hearing that, everybody wanted to give him death. Right. Patrick Henry accused the framers of this document of creating a presidency that was akin to a military monarch, and he actually quite clearly said, this president will impose a despotism and he will take enlarged armies and send them off on military adventures. No one in any of these debates in any of the states ever said the Declare War Clause was a check on this possibility. Instead, James Madison, who we just heard about 1793, when arguing with Henry in those debates, did not make a peep about the Declare War Clause. Instead, he said the check on supplies will be the main check on the legislature, just the way it is in Great Britain. That was his response when he was confronted with that argument. All the quotes that take place to me after 1787 and 1788 aren't as important because they are after-the-fact interpretations of the Constitution. They're not what was said by authoritative people trying to get people to vote and approve the Constitution as it was done. Second thing they say about, I think the most important quotes are from this debate between Helvidius and Pacificus, or Madison and Hamilton in 1793. Madison did say exactly what Alberto quoted him say. I just want to put it in context. Madison, I think, was the great loser in that debate. Madison's position in that debate was that the president was not even allowed to say that the United States was neutral in the what would become the Napoleonic Wars, that the Congress, only the Congress could set foreign policy, and the president just had to carry it out. He turned out to be wrong, not as a matter just of then, but ever since. We've always thought the president is the one who gets to decide on things like neutrality. And then look at what Madison and his good buddy Jefferson, who wasn't even present in the country during the ratification of the Constitution, did when they got into office. Right? they sent the entire US Navy on a quote-unquote training exercise to the Mediterranean and to train further with the Barbary pirates, right? And they secretly ordered that fleet to attack and destroy the Barbary states if they could, which one of them did. There was I can't be, it would be too good if it's true, but I think it might have been the Enterprise. The USS Enterprise actually fought and destroyed one of the first Barbary pirate ships it came across. I think that's right. Only after that all happened, Thomas Jefferson went back to Congress and said, oh, look what I did. Will you give your blessing to it? Neither Madison or Jefferson or any of the other cabinet officers, when they were talking about this, thought that they had to check with Congress first before they sent the fleet off to the Mediterranean to attack the Barbary pirates. I'm afraid a lot of the other quotes have this similar problem or defect in that they come years afterwards. Like Washington's quote. Again, I'd like to pay a lot of attention to what Washington said in 1793. He didn't say this during the ratification debates. And in fact, when Washington became president in 1789, one of the very first things he did is he ordered the U.S. Army to go and attack in offensive operation Indian tribes on the western frontier, and he didn't feel he had to get Congress's permission for that either. He may have said that in 1793. I think in all these quotes, many of them are referring about changing the state. That's the phrase they kept using, changing the state of the nation from peace to war. Actually, I think which is consistent with the idea that the Declare War Clause, which is what the argument hinges on, I think on the other side, is about changing the legal state between the United States and other countries, but that's a separate issue than starting military hostilities. Lincoln, I think, is the Lincoln quote, I think, and Alberto, again, he's such a dastardly guy. He's quoting Lincoln. He knows Lincoln is my favorite president, and I try to quote Lincoln every time I can. And he uses this quote from Lincoln, but it's Lincoln in 1848 as a one-term congressman, right? Lincoln is the greatest loser in American history. I mean, he gives hope to losers everywhere because he loses over and over again, and then through some quirk of fate, he becomes president in 1860. His quote, this great speech he gave in 1848 is pretty much ignored. He's not even reelected to office. But when Lincoln is president, does he wait and ask for Congress for its advice on what to do at the start of the Civil War? Right, on the firing of Fort Sumter, does Lincoln call Congress into special session right away to get appropriations for military? No, he waits till July 4th for Congress to meet, and in the interim, he raises the army himself, takes money out of the Treasury, sends them into the South, and begins offensive operations well before Congress can meet to talk about how to respond to this war. And I would say that's a great example of why the Constitution does give that amount of authority to the president once there is a war, because we want the president to respond quickly. Imagine what would happen if Congress was in charge of figuring out what to do in response to the firing of Fort Sumter. You don't have to imagine. When the southern states started seceding, what did Congress do? Anyone here work in the legislature? I have. I have worked in the legislature. You could have predicted. They set up a special committee to study the problem. Every state had one member on the committee. Of course, and one wonders what's going to happen with the debt super committee, but this committee in the end never did anything, and it was up to Lincoln to take charge and decide what the response was going to be. The last thing I'll say is Alberto's quite right. Even if you disagree about this issue about the framing, one has to have a view of what do you do about change over the last 50 years if it's at odds with the Constitution. All I would say is that, to me anyway, this practice of war powers where the president and Congress are constantly struggling for the upper hand, that to me seems more true to the original Constitution, or at least is not the biggest deviation. But I would just say, and I don't think Alberto is in this camp, I don't know, but often this argument is made, that Alberto has made, I find it funny because usually these folks are more than happy to have the broadest, most expansive powers for the president when it comes to what I think is probably the biggest distortion from the original constitutional design, which is the massive administrative state we have.
10 seconds.
I think it's odd often, usually people say, oh, well, we shouldn't stick to the original meaning of the president's powers when it comes to the president's domestic authorities and overseeing an executive branch that has millions and millions of employees and consumes billions and billions of dollars. Right? That, to me, is the one that you should worry about, not the presidency acting so closely, I think, to the core of his originally intended responsibilities. So thank you very much.
Alberto, 8 minutes.
Yes, I'd like to ask this question. So what John is telling us is that we only pay attention to the text of the Constitution, but not to the statements made by the people who drafted the Constitution simply because they were made afterwards. So we should ignore even the writings of Alexander Hamilton, who was a very strong friend of a strong presidency, when Hamilton says only the Congress can put this nation in a state of war. And I find that very difficult to accept, that we say, well, we're only going to stick to what the Constitution says. He says, well, the Constitution says Congress shall declare war. And then John says, well, and of course, declare war meant only this. It made, he talks about the declaration of war meaning only an international declaration. It's a way of telling the world that we are now at war. Now, traditionally, in many societies, including going back to ancient Sparta, okay, a declaration of war was not just a way of telling other nations that you were at war. It was also intended to have domestic effects. It was a way of saying, we have come together as a people or as a leadership, and we have decided that this country now needs to be put in a state of war. Now, secondly, on the Pacificus Helvidius debate between Hamilton and Madison, it is true, Madison wanted even more power for Congress, and he lost that debate. But in this debate, Hamilton is very straightforward, as I read to you, that yes, the president is the commander-in-chief, and the neutrality proclamation, the president could issue a neutrality proclamation because it involves saying the United States will remain neutral, okay? And neutrality usually means, as he puts it, the blessings of peace, prosperity, commerce. But when it comes to putting the country in a state of war, Hamilton in that debate says only the Congress can do it. Now, his references to the Barbary pirates, I mean, that was a defensive operation. Okay? The Barbary pirates had been preying on American commerce for years. They had been demanding and getting tribute from the American government. And under the Constitution, the president was entitled, in his capacity as commander-in-chief, to respond to a legitimate attack on American commerce. Same thing with President Washington's actions on the western frontier in response to Indian attacks, as opposed to launching an offensive war. And Washington makes it very clear. If it were an offensive war, I would have to get authorization from Congress. Okay? And then, you know, there's the point about Lincoln and the Civil War. I mean, the reason that Lincoln could act, okay, as he did without consulting Congress was twofold. Number one, Congress at that time still had a large number of Southerners who had not yet left. So Lincoln could not call the Congress and say, give me the funds to invade the South, okay? Because these Southerners, in fact, wanted the Union broken up. So this was an unusual historical situation in which Lincoln had to act. And all of this came to a head in the famous Price cases before the U.S. Supreme Court in 1863. And Justice Greer, giving the opinion for the court, said that the president, as commander-in-chief, had no power to initiate war, but he did have the authority to put down a domestic rebellion, which was what the Civil War was. And so when Fort Sumter was attacked, of course the president has the authority to respond, as Hamilton put it, as Madison put it in one of the debates in the Constitutional Convention. The president has the power to repel sudden attacks. And so Lincoln, yes, he had the authority to respond to a group of Southerners attacking Fort Sumter. But Justice Greer in that case says the president had this power, okay, but he did not have the power to initiate the war. The problem was the war had been initiated by the South, and he had the authority to respond. So we really come to the question, two issues, okay? This whole practice of presidents over the last 5 or 6 decades strikes at the root of what Republican government is about. And Republican government is about the government of the many. And the idea that the decision to go to war is more momentous today than ever in our history. Think about the power of weapons of mass destruction. Think about the implications of a war. Is this something that we really want to put in the hands of one man? The founders believed that Congress was the appropriate instrument to debate and to decide that because of one key virtue that the Congress has, in spite of everything else that's wrong with them, and that is the virtue of deliberation. And the founders had read their Aristotle, and they had read the Nicomachean Ethics, and they knew about prudence. And the highest political virtue in statesmanship is prudence, practical wisdom in politics. And central to prudence is the exercise of deliberation, the capacity to debate, to discuss. And only a body elected by the people's representatives can and should deliberate on that highest of questions. And then secondly, of course, there is the question of emergency. You know, we have grown used to presidents claiming powers to respond to emergencies. And I just want to close with a quote from Justice Jackson in the Youngstown Steel case. 1952, President Truman decided that as commander-in-chief during the Korean War, he had the authority to seize the nation's steel mills and run them, because in a war you need steel for production. And Justice Jackson, who had taken a stint off the court to serve as an American prosecutor in the Nuremberg trials, wrote this, very applicable to this day. Loose and irresponsible use of adjectives colors all non-legal and much legal discussion of presidential powers. Inherent powers, implied powers, plenary powers, war powers, emergency powers. The vagueness and generality of the clauses that set forth presidential powers afford a plausible basis for pressures within and without an administration for presidential action beyond that supported by the Constitution. And then he adds, the founders knew what emergencies were. They knew the pressures they engender for authoritative action. And they knew, too, how they afford a ready pretext for usurpation. They also suspected that emergency powers would tend to kindle emergencies. Yet they made no express provision for exercise of extraordinary authority because of a crisis. With all its defects and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law, and that the law be made by parliamentary deliberations. Such institutions may be destined to pass away, but it is the duty of this court to be last, not first, to give them up. And I suggest to you that ultimately, to the degree that the world becomes an increasingly dangerous place, the matter of putting this country in a war, even in an intervention as seemingly harmless as that in Libya, which I supported, but in which I felt that President Obama was wrong not to seek congressional authorization.
10 seconds?
These crises have the potential to escalate into larger crises, and it is precisely there that we need the deliberation of the people's representatives as the best guarantee of prudence in politics. Thank you.
Thank you both. So now time for question and answers. A couple of things. Our rough notion is to end about 8 o'clock, but if there are folks who've got kids to put to bed, trains to catch, or given how many damn lawyers there are here, billable hours to rack up before you go to bed, feel free to quietly exit. I also want to slightly appropriate a thought from Judge Easterbrook of the Seventh Circuit. If you missed, there was a terrific panel that preceded us here today, and basically say this is a question and answer period coming up, not a sort of declaration and / polemic period. So no matter how pissed off you might be at something somebody said, if you can sort of do it in the form of a question, appreciate it. I'm going to start with maybe 1-2 quick questions. And again, we'll start below, go up top, and if there are folks in the overflow room, we'll get to you. Let me ask both you guys, does the president have the authority to use torture even if a federal law expressly bars its use? Not all at once?
I think Alberto's answer is obvious. All right, so I'll go first.
Please.
Yeah, so first of all, let me say I don't think this is a question we faced in the Bush administration, because we did not think that we were overstepping the federal statute. But in the opinions that I worked on, we did tackle that question because we realized that the statute was vaguely written and people could have disagreements about where the law and the line sat. But I just want to say at this point, I'm just talking hypothetically because we don't think we actually had to make a decision on this question when I was in the government. I do not think that as a constitutional matter that Congress can instruct the president on how he has to fight a war, either with the strategies or the tactics. And that includes not just interrogation methods, but detention or use of certain kinds of munitions, like nuclear weapons, or taking it to a level of strategy, things like whether to invade Europe first or Japan, or where to place the bulk of our resources. Again, as I said, Congress has lots of ways to affect these decisions if they want to. For example, take Guantanamo Bay, right? Congress didn't want the president to close Guantanamo Bay, so they essentially cut off all funds that would allow the president to pursue any other alternative other than keeping Guantanamo Bay open. I certainly think that Congress, if it doesn't want tougher interrogations than the president wants to carry out, they can use their funding power just to eliminate the units that would be carrying them out, or to eliminate the training for interrogation. But what I don't think the Congress has the power to do is to instruct, the Congress can instruct the president how to wage war. Now that's a different question actually than the one we've just been debating, which is who gets to decide when you start it. And actually it would seem to me, however you come out on this question, how you start it, once you actually decide on the war in a constitutionally appropriate manner, then I think my argument gets stronger, not weaker, that once the war starts, then the president, as commander-in-chief, his constitutional authority is even greater because he is the commander-in-chief. And it doesn't say anything in the Constitution about Congress getting to decide once war has kicked off how to decide on the waging of it. And I think there are a lot of quotes, I think from the Federalist Papers, from the ratification period, that do talk about this directly. In Federalist number, I think it's 70, Alexander Benjamin Hamilton says, perhaps the first duty of the executive is the administration of war.
I think that the president's role as commander-in-chief, let's remember what it is, okay, under the Constitution. The president is not the commander-in-chief, okay? He's not my commander-in-chief, and he's not your commander-in-chief. The president under the Constitution is commander-in-chief of the Army and Navy of the United States. I think that his powers as commander-in-chief of the Army and Navy are extensive, and he does have broad authority on how to conduct the war, but I would make certain qualifications. The president cannot violate a congressional statute in the name of his powers as commander-in-chief. In the hypothetical that our moderator has posed, the president decides to give an order to torture somebody, okay? Now, under American law, torture is illegal. There is a congressional statute that prohibits torture. And I think that the president cannot use the commander-in-chief power to say, well, yes, there is a law that bans torture, but as commander-in-chief, the Congress cannot tell me how to run this war. The Congress cannot tell me that in the course of running this war, I cannot torture people. Because I think that logic would be extremely dangerous. It basically would mean that in his role as commander-in-chief, the president is not subject to the law. And I would like to suggest that even in his role as commander-in-chief, the president is subject to the law. Now, there are certain laws that might be inappropriate for Congress to pass. I mean, for example, Congress might pass a law in the middle of a war, in the middle of World War II, saying the president cannot at any time use tank divisions except under certain circumstances, okay? And that would be considered a matter of tactical warfare, a matter involving the president's judgment as commander-in-chief of the Army and Navy. But when we talk about a law banning torture, okay, this is a law that strikes at basic principles of American constitutional tradition, and it is also a law legitimately passed by Congress. You know, after all, Congress gets to pass laws saying, for example, literally, how many people we will have in the armed forces, okay? Congress gets to pass laws administering the armed forces. The armed forces of the United States, by the way, in their trials and in their legal proceedings are administered not by the president, but by a manual passed by Congress, okay, called the Uniform Code of Military Justice. So Congress has a great deal of discretion in the administration of the armed forces, and in the Pentagon we used to say the president has operational control, but the civilian secretaries retain, and of course they're also presidential appointees, but they retain authority for the administration of the armed forces. So the president cannot break a law. Cannot break the law, and this, I would say, in this hypothetical, he would not be able to.
John, let me maybe you can wind it into this, and then I swear I'll get to everybody. What about the use of?
By the way, he's just getting his students to clap. That's also unfair.
I told them not to. I told them not to. They're misbehaving.
Let me ask you.
Actually, if we were in
You
Berkeley,
won't get any better grades for that.
if we were in Berkeley, they would clap for you too.
John, let me ask you, what is your view, your guys' view on the executive's right as far as the use of executive power in secret? It seems to raise, the dual problem of the use of executive power, but also the ability of other branches to even question what it's doing because it doesn't know, because they don't know.
Yeah, I just wanted to say something very briefly about Alberto, so I think it does tie into this question. As he said, the president can't violate the law, but every law passed by Congress is not constitutional, right? Marbury versus Madison makes that clear, that there are going to be conflicts between the law and the Constitution. The highest law is the Constitution. And so actually all these questions require us to fall back on the issue, what is actually the constitutional scope of the president's commander-in-chief power? So I would say if it can't be the case that Congress can just pass any law at once with regard to the conduct of war, and they're always constitutional, right? Because that would effectively make the Congress the commander-in-chief, not the president. Why doesn't let Congress say, you can't interrogate anybody, you can't detain anybody, you have to release everybody when they're captured in war, and you can't use drones too while you're at it, and no nuclear weapons and any other, where does it stop? I think that the reason why we have this, I think, intuition that that shouldn't be the right answer either is because there's some line that the Constitution creates between what's the legitimate commander-in-chief function and what's Congress's legitimate function. And every law Congress has passed cannot just be per se constitutional. I think that goes to the other question about the, well, maybe it doesn't at all, but I'll pretend, the question that you just asked, which is the executive acting in secret. Because I think Alberto was right in the thing he said at the very end of his initial remarks, is that we are a Republican government, obviously, and Republicanism, at least as the way his favorite Greeks understood it, was the idea of rule by the many, although I don't want to instruct Alberto because he knows the Greeks far better than I, but they were not the greatest friends of democracy, right? A lot of them had doubts about democracy. But the idea that there should be rule by the many is not the constitutional system. Right? And you see that in the executive, but you see it in things like the Senate. You see in lots of the judicial review. You have a lot of features of the Constitution where we don't let the multitude decide every question. That was actually the system that the framers rejected. That was actually the pro-legislative, most Republican governments of the period between the Revolution and the Constitution. And that becomes most acute when it comes to foreign affairs and national security. Because even though we may have a government where we are, in some sense, Republican, we don't want everyone to have a vote or every congressman to have a vote on everything. In fact, Congress itself wants the president to act in secret at times. Right? I just mentioned one type of law, the laws that govern covert action. We don't think that there should be big public debates and congressional votes on every covert action before they occur. We've worked out a system in secret where the executive branch is responsible for developing them and notifies Congress in a finding, actually notifies just a very small number of congressmen and congresswomen just on one committee in a finding. There's no vote by Congress as a whole. There's no legislative authority before the act takes place. Right? That is something that the framers were very worried about, was that if you had too many people involved in a decision, especially in foreign affairs and national security, you will have paralysis. That's why the framers talked very deliberately. They actually talked probably way more than was healthy about the Romans. And they said that we should not have a Roman system where you had two consuls, because even to have two people in charge of the executive branch would be disastrous, because you wouldn't be able to act quickly and secretly, they said, and secretly and swiftly. So I think the framers did set up a system where the executive branch was supposed to act in secret, and the way our system has worked to accommodate that with Republican government is to have notification of different branches, parts of Congress, but not to have some kind of open debate on the Hill, because if you start discussing some of these things in public, you're going to actually, it'll be counterproductive, and you'll actually frustrate the purpose that you were acting in the first place. Alberto?
I have to agree with much of what John has said on the issue of secrecy. I think there's a legitimate need for secrecy in military matters and matters of national security, and it's quite appropriate. And in fact, presidents from the time of Washington have acknowledged that, and Congress really has not objected a great deal. I think most people in Congress understand that there are pieces, for example, of the military budget, huge pieces about the procurement process involving what kinds of weapons we design and develop and purchase. That should not be open knowledge. So I think that's that's a very broad issue on which John and I can agree. I do think, though, that I want to go back to the point about Republican government and say that, yes, the founders did not want a pure democracy in which everybody would be deciding the question of war, but they clearly intended that the momentous question of putting this country into war should be decided by the people's elected representatives. It should not be decided by a single person. And that doesn't mean that they were pure Democrats. They were not Athenian Democrats, but they certainly believed that, as they wrote over and over again, they warned against the dangers of kings, against the dangers of the British monarchy. And they made a very specific point of saying, we are borrowing some very good features from the British system, but we are rejecting some. And one feature that we're rejecting from the British system, several of them said, is that under the British Constitution, the monarch makes the decision of going to war, but under our system, we're not going to put that in the hands of the executive, though we will put in the hands of the executive the power to command the armies and navies in wartime. And Hamilton said, in essence, this means that the president is the first general and admiral.
Let's now go to questions. Let's right here, and feel free just to ask a question to one specific person, and you guys can play it by ear. You need not both respond if you've got one just for one of the guys.
Thank you. David Applegate with the Chicago Lawyers chapter of the Federalist Society, and also an active participant in the American Constitution Society. Two very brief questions. First, with due respect for the eloquence and arguments on the negative, my question for Professor Coll is, in this era of the living Constitution, why should we expect that the United States Congress, one house of which is the world's greatest deliberative body, which has not been able even to pass a budget in 3 consecutive fiscal years, could possibly be expected to respond quickly enough in the event of a national emergency? Second, for both gentlemen, because you're both fans of Thucydides and the idea for this event.
I tolerate Thucydides.
Well, all right. Because this arose in a health club, what is each of your personal best bench press records?
Bench press? Bench press. Only in Chicago.
No, people always make this argument about Congress. They cannot decide this, that, or the other. How do we expect them to decide these things? First of all, again, I want to make a distinction, okay? If the President of the United States received intelligence tonight that we are about to be attacked by some other nation, or that some state out there is about to launch weapons of mass destruction against us in the course of the next few days or even the next few weeks, would he have the authority to respond without calling a session of Congress? The answer is yes, okay? But the problem that we have had is that many of the wars that we have been involved in, certainly the most expensive ones in terms of American lives and treasure, have been wars of choice, in which we have had months and months and even years to discuss what we should do. And instead, the president, and the most scandalous thing about this is, as John said, the first Gulf War received authorization from Congress, and the second war, the Iraq War of 2003, it also received congressional authorization. But the scandalous thing is that President Bush Sr. and President Bush Jr. and also Bill Clinton with regards to Kosovo, they all said, I'm doing this on the basis of my own constitutional authority as commander-in-chief. So they're basically saying, even in case of wars of choice where U.S. security is not threatened and where we could have a legitimate debate about what the national interest of the United States is, we don't need to consult the people's representatives. I suggest to you that if the Congress had to decide these questions, that they might act more responsibly. And I'd like to suggest also that this is really an issue in which Congress sometimes can do a very good job. I mean, the debate in the first Persian Gulf War was a magnificent debate in both the Senate and the House. It was worthy of our best political traditions. And so I think that this is the way that the Constitution says it should be, and I would be very worried about simply over time creating a system in which we expect the President to decide this.
So I think the answer to your second question depends on how much the bar weighs that you put the weights on. Is that right? I just want to raise two cases because I think if you buy Alberto's argument that I think you have to be willing to live with the consequences of decisions that never would have been made because there's all the evidence in what Congress would not have been able to act because of their large numbers or just inability. So one would be the Cuban Missile Crisis, right? President Kennedy's thought to be his finest moment, right? Remember, there's no imminent attack on the United States threatened. All the Soviets are trying to do are assemble, they haven't even put them together, assemble missiles in Cuba. President Kennedy puts up without congressional permission, or UN permission might add, a blockade around Cuba with the Navy, which used to be considered an act of war, with orders to stop Soviet freighters carrying missiles to get to Cuba. Violation of international law unless we're at war, right? Congress never approved that. President Kennedy, I think, could only have done that under his executive authority. The other question I'll take as a point two is something that happens during war, is the Emancipation Proclamation. Again, a unilateral act by the president freeing all the slaves in the South as part of his commander-in-chief authority, at odds with congressional statute at the time. Right? Congress, of course, again, not to make too much fun of Congress, but when Congress handled the question of emancipation, they had their own statute out there, which was that any slave that was to be freed, there had to be an individualized hearing before a federal judge to prove that the slave owner was a member of the Confederacy. And I don't know about what the docket loads are like in Chicago, but I can guarantee you we'd still be hearing those cases today if that was the governing policy as to emancipation. President Lincoln acted contrary to that statute and freed all the slaves in the South, but it was a commander-in-chief decision, which is why he didn't free the slaves in the loyal parts of the North. Would you be willing also to live with a world where Soviets did build all the missiles in Cuba and radically change the balance of power, or where slaves were not freed during the Civil War?
I think we had one more down here, then we'll go upstairs. Was a gentleman here right in the front row to your left.
Yes, this is for Professor Yu, a question about hanging your hat on the evidence associated with the ratification conventions. You focus on Virginia, but Virginia's ratification does not a constitution make. So you have to tell us what the evidence is from other jurisdictions. And second, how, when we have that evidence, do we disaggregate the up or down vote on the Constitution, given the different debates and the different issues focused there? And third, to the extent the record is silent, why not go with what Alberto Coll has said, which is the recollections of those involved later on?
So I'm going to try to be brief, because if I go into this in the detail, I would like no one will ever come to a Federal Society meeting in Chicago again. First, my examination of the other jurisdictions is that either this issue didn't come up, or when it comes up, you never see the declared war clause mentioned. That's the really weird thing about the ratification debates, is that the Federalists, had every incentive to try to downplay the size of the executive, right? They wrote this Constitution with a pretty broad executive, then they have to sell it to the states. They're the only ones that have the legal authority to adopt it. I've long thought that the debates of Philadelphia are very nice, but they don't have any sort of legal authority in the sense that the states do, because the states are the ones that legally adopted the Constitution. In those debates, you just don't see it. There's one person in Pennsylvania, James Wilson, who says the Constitution is designed so that one person can't take us into war, right? I tend to think that's because it's obvious that Congress has to pay for the military, raise it, and declare the legal state of, I mean, the president couldn't, under even my vision, take us completely into war without Congress's cooperation. So that's but most of the other jurisdictions, it just never even came up. Or Massachusetts, the key ones, Massachusetts, New York. The Virginia one I actually think is critical because Virginia was really the state where all the arguments came to an head. It almost failed in Virginia. And if Virginia had voted against the Constitution, I think it's highly likely that we would have had to have another constitutional convention. And so it really has that element of what the political scientists call a veto gate in a way. As to the silence, I didn't catch the second question. I was too busy writing. So I'll take the third, which is silence. What if the ratification is just silent? Then why don't we go to the post-ratification history? Well, I think the problem is that look at the incentives of the speakers. Once the thing is ratified, you have political parties form. They have the incentive to interpret the Constitution at that point just to advance their own political goals, which wasn't necessarily going on before 1789, before there were any political parties. And I hate to talk about Rawls, but this is kind of like Rawls's veil of ignorance, right? You don't know in 1787, 1788 what's going to happen. So I tend to think they're more reliable. Afterwards, take Madison's discussion in the Helvidius Pacificus debates. Madison had been, probably the father of the Constitution. When he's saying the words in 1793, he has already set up with Thomas Jefferson basically the first political party, the Democratic Party, and their objective was to attack and drive Washington out of office. I just don't take those interpretations of the Constitution in that heated partisan moment as seriously as statements made by Madison before he's in politics.
I'd like to add a couple of points to that. One is I think that one reason you don't see as much of it was that there was an implicit understanding that this was very obvious, that, of course, the legislature should have the power to move the country into a war. And I mean, I even go back to the constitutional debate, Ellsworth Gerry's, this was from Madison's notes. Mr. Gerry never expected to hear in a republic a motion to empower the executive alone to declare war. It was a very large consensus that, in fact, this would be one of the key distinctions from the British monarchy. So that's why you don't see as much of it. On the second point, I'd like to suggest that John's argument falls on the debate between Madison and Hamilton, because these two rivals, they're forming separate political parties, and yet they both agreed on the one point that we might disagree on various degrees of presidential power, but we are agreed that only Congress can put the country in a state of war. So I find that the post-constitutional comments are not all biased by various political agendas. There is still this common consensus at the core.
Do we have anybody upstairs?
Question for Mr. Yu. Connor McKell, student at DePaul Law. If I might just briefly get away from the ivory tower of the Division of War Powers for a second. Your contribution to the efforts of the Bush administration, specifically in preparing memorandums that paved the way for the support of a condonement of torture abroad, I think will be your defining legacy. I think at the moment it is assured that in darker corners of this world, there are captors facing the unrestrained brunt of their interrogators, which is a direct consequence of your contribution to the Bush administration. I'm wondering on a personal level, as you stand here in the cozy confines of the Pritzker Library, how do you square that against your conscience on a personal level? Thank you.
Sure. I mean, I'm glad you asked that question. I would have liked it to be a little shorter, but I'm glad you asked it. First, if you look at those memos closely, they don't actually argue for any kind of interrogation method. There's a job for lawyers and there's a job for policy. I think lawyers interpret the statutes and the Constitution as they exist at the time. I still think it's up to the policymakers to decide whether to form any kind of policy within the limits set out by the law. Now, you may think that this keeps me up at night, worried. I don't sit up all the time in terms of my personal conscience worrying about whether we made the right call. I think if you go back and look at the facts and the situation that we were in, within 1 year of the 9/11 attacks, and you want to contrast it to the comfortable Pritzker Library, and I should add, I didn't, but I wanted to say this is a wonderful facility, and thanks for having this debate, because When we have debates in California, given the budget, we just go out into a grassy field and sit in a circle now. So it's I've never been in a facility, I've never been in a facility this nice before, actually.
You have a nice stand, John.
Is that we haven't had an attack in the last 10 years. The reason it is comfortable and nice in the Pritzker Library, I think, is because of the policies the Bush administration put into effect, which I think were remarkably successful. And the Obama administration has continued, mind you. I mean, it's not a partisan issue, which prevented any terrorist attacks from occurring in the United States and the homeland for the last 10 years. And some people, I assume you take this position, would say, but what costs us civil liberties? To me, I look around the country, I think civil liberties are in extremely good shape. You have never seen a level of political organization and discussion and mobilization like we've seen over the last 10 years. And that's not because the government fostered it. It's because of the internet and social media and all the new forms of communication and organization we have. But I don't think that the government in this war, like past wars, has suppressed civil liberties, has tried to prevent political speech, has tried to prevent political organization. Instead, our system has worked. We have had highly contested elections, bitterly contested elections over the last 10 years, and that's the way, I think, if there are abuses on power, that's the way our Constitution actually provides a remedy. And we've had, think about it, we've had the presidency change hands in terms of political party already once, I think the Senate twice, and the House of Representatives 3 times now in the last 10 years. That to me, and during that time period, Congress has had the opportunity to reverse all the policies you're talking about, and it has not.
Another question Anybody else upstairs? Sir, as gentleman in the front row.
Hi, I just wanted to thank you both first for talking. It's been very enlightening for me. My question is for Professor Coll. It sounds like you both agree, at least to some extent, that the president should have the power to respond to some emergency, or Professor Coll would call it self-defense. I think it might be just a question of label, but my question is, how do you draw the line between self-defense and declaring war? Because I think, Professor, you brought up a good point with the Cuban Missile Crisis. It wasn't exactly an immediate threat, but we could all agree it was something that seemed pretty important.
I would like to take that on first. The Cuban Missile Crisis was an example of self-defense. And I think the classic definition of self-defense, probably the best known one in American history, was given by Daniel Webster, Secretary of State of the United States at the time, when he talked about self-defense, and he talked about a situation leaving no moment for deliberation, no choice of means. There was a great time pressure in the Cuban Missile Crisis, because if the missiles had been assembled, and it was only a matter of days and weeks before the missiles could be assembled, then you would have Soviet missiles on Cuban soil at that time with the capacity to threaten a whole new range of American cities far more effectively than at that time Soviet missiles could do from the Soviet heartland. And so it was an operational emergency. It was not just something that could be debated for weeks or even months. Okay? Now, John gave the example also of the Emancipation Proclamation, and that's a tougher issue. That's a tougher issue. And I would just say this was an issue involving the liberation of human beings in a particular part of the country where the president thought that it would help achieve the war aims. And so it might be a good exception. But remember, good exceptions can make for very bad principles. If you take any exception, every exception, and you turn them into general principles, you can run into a great deal of trouble. So the line of self-defense, sometimes it's hard to tell, but for example, I would say the invasion of Panama, that was not an act of self-defense. It was totally inappropriate for the president to invade a country, overthrow its president without any kind of congressional authorization. Okay? And the case of Libya, clearly totally inappropriate for the president to intervene militarily without congressional authorization.
I'll have to ask the folks in charge if there's anybody in an overflow room who's got a question. Okay. It's a little bit after 8, so this was going to be our appointed departure time, but if there are some, feel free to raise your hand. Other folks, not nervous about leaving, but if you got a glass, remember, just leave it outside. How about the gentleman right on the aisle, right there? Yeah.
So I think this is primarily for Professor Yu, but either of you can weigh in. I wonder whether if in practice or in principle we put the onus of responsibility on the president, as Professor Yu has proposed, whether in practice then we don't really put ourselves at the mercy of history and of presidential personalities, and more importantly of presidential history itself. You know, take the example of President Truman, who I think we would probably say gave a very broad interpretation of his own authority because of the fact that he succeeded President Roosevelt, who had been very successful in pursuing his own broad authority, or the reverse, President Ford, who, coming on the heels of the Nixon administration and the embarrassment that accompanied President Nixon's withdrawal from office, saw his own executive authority very narrowly. And, you know, that puts a different light on the kind of the self-understanding of every president's authority, when it's not just a matter of a reading of their power under the Constitution, but a reading of their power as the country at large is inclined to understand it. And that really puts each president at the mercy, to some extent, of their own predecessors. And I wonder whether that doesn't implicitly cause its own problems.
That's a great question, because I do take your point that if you concentrate all this power in the presidency, isn't that, I would say what you're saying essentially is, isn't that really risky? Because it really then depends on the kind of person that you have in the office. And to make it even stronger, I think you can go back over our history. You know, not every, you know, despite what you read in the kids' books, not every American president was a great president, right? We've had a lot of bad presidents too. Again, I would say like President Madison, who should have not gone to war in 1812, got pushed into it by Congress, and he was a weak president, actually. Because of that, I think we got into this stupid war where our capital was burned and our country was almost taken over and cut in half by the British. I think the question, though, is you're going to have mistakes either way you set it up. And the real question is, which way do you want to, which system will have the least costly errors, I suppose is the way to think of it. So sort of fancy way of saying what Alberto has been saying is that there's this, so I've been referring to these people I don't like Thucydides now, and Rawls, and now French people. So there's this French guy named Condorcet who has this theory called the Condorcet jury theorem, where his argument is the more people that get to decide a question, the more likely they're going to be right. They don't even need to deliberate, actually. You know, the more bigger jury you have, no deliberation, they're more likely to get the answer right. So, I mean, that's the sort of fancy way, I think, of explaining Alberto's claim about let legislatures decide, especially really important questions. But there's an error cost, too. The error cost there is that legislatures are big, they are slow, as the first question, they don't like to take responsibility. There's huge difficulties in ever getting Congress to act. I mean, as he said, they can't even pass a budget, not to mention make decisions of high diplomacy. I think our Constitution biased it in favor of a single president in foreign affairs so that you could have swift, secret, and decisive action, as Alexander Hamilton said. I'm not saying that's a cost-free, perfect system, but to me it seems that will produce less harm to the country and more opportunity to gain than where Congress had decided. And we've had bad wars, too. But the wars that have been really bad for our country in terms of lives lost and costs were ones that Congress approved, too. If you want to say Iraq and Vietnam were the two most mistaken wars we've had, if someone has that view. Those are both approved by Congress. Those are not examples of unilateral presidential adventurism. Right? Those are the two branches we're in agreement. Alberto?
I think the founder system is preferable to John's suggestion here. And I know John doesn't like the analogy used by John Hart Ely of the two keys. You know, John Hart Ely said you need two keys to get the country into war. One key by Congress, one key by the president. But in fact, the example of James Madison proves it. Okay? Congress can want war all it wants. If the president doesn't agree, the country doesn't go to war. Okay? Congress could declare war tomorrow on Iran. nothing would happen unless the president, as commander-in-chief, actually directed American forces to attack Iran. So the system, and some of the founders talked about a system in which you would clog the tendency towards war, towards offensive, unnecessary war, as opposed to defensive war where you're attacked or you face a dire threat. And so, the war against Iran would be an example. If President Obama thought this was very unwise, or if President Madison thought that it was very unwise to go to England, he could have just sat and done nothing. And constitutionally, that would have been exactly the way to go. I think that's a better system than one in which only one person, the president, has the key.
Can I ask you guys a question that is inspired by the really terrific previous panel, which is, given the inherent global premises behind the war on terror, who, how, and when does one decide that the darn thing is over?
Is this the last question?
No, this is my last question, then maybe somebody else has one.
Okay. To me, I guess I would say this is not strictly this question of a president versus Congress. I think both President and Congress could effectively end the war whenever they want. The President could stop fighting it, as I wish Madison had not fought the War of 1812. Congress can just stop paying for it and start removing the tools that the President wants or needs to wage a war on terror. So they could both, I think, constitutionally effectively stop it. In terms of when it actually ends, I don't think we're at a war with terror generally. Terror is a tactic. It's not an enemy. We are at war with the Al-Qaeda terrorist network, and any countries and terrorist networks that helped them on 9/11 are harboring them since, which is basically what Congress said in the authorization to use military force. When that actually happens is a hard one because we're not fighting a nation state, as Judge Easterbrook mentioned during the previous panel. So that makes a lot of these legal issues, which would normally be much easier during wartime, very hard, because we're definitely not going to get Osama bin Laden to sign a peace treaty on the bridge of the USS Missouri. And I doubt any other head of Al-Qaeda is going to sign a peace treaty with us, and they wouldn't be able to get their members to obey it probably anyway. So I think it's going to come about when we have so degraded the abilities of Al-Qaeda to launch attacks on the United States that they are no longer militarily effective against us. That, I think, is when the war, that's when the war will be over. If you listen to what people are saying in Washington, I don't tend to believe this, but I don't have access to intelligence anymore, but based on what they're saying, they think that's within reach now. There have been all these briefings on the Hill now which say that the Obama administration's intelligence people are saying that we're close, that you can actually see a point where we are going to achieve that objective. And if I think that happens, then I think the war is over. Alberto?
I agree with much of what John has said. And I think, though, the problem is that in every generation there will be new groups, new technologies, new movements around the world, be they religious, political, that will seek to attack the United States. And so we will face all these dangers for many generations. One problem with that, though, is that we can no longer say, well, the president can detain somebody indefinitely until the war is over. I mean, it does affect the way that we look at these legal issues. If we believe that this war is going to last our lifetimes, and it may well last a lifetime, then we have to think differently about how long can a certain person be detained without being put on trial or without a process by which that person can challenge their detention.
Final, last pre-dinner question. Let's go upstairs. I think in the front row.
Thank you. Professor Wu, could you take on Professor Coll's comment that the Commander-in-Chief is the Commander-in-Chief of the Army and the Navy? And if there were a domestic situation that was parallel to the Civil War or a state secession or an internal insurrection, what would be the role of the president versus the role of the legislator in saying what can the president do to detain people, interrogate people, prosecute people, versus what the legislature could put bounds around?
I have to say I disagree with Alberto's argument that the commander-in-chief position is sort of like just being the top officer. I think there's the commander-in-chief and his power as chief executive, which is not enumerated in the Constitution, are the broader reservoirs of that authority. And so it's, I think, more than just a provision which establishes civilian control over the military in terms of giving orders. And I think it's been understood as that from the very beginning of the country. So the Neutrality Proclamation we were just talking about, the idea that the president gets to set foreign policy and whether we're friendly to some nations and hostile to others, if you look at the Constitution, it doesn't actually say who has that power at all. We have always inferred it in the president because of his powers as chief executive and the commander-in-chief. Why does the president get to fire anybody in the executive branch? Again, that power is not set out in the Constitution, but we've inferred it as part of the chief executive power because it's not specifically taken away by the Constitution and given to Congress, which is Hamilton's argument about how you interpret the powers of the president. In terms of the second question, what would happen if there were, again, some kind of domestic insurrection? Look, Lincoln, I think, established the outer bounds of this. I mean, in many ways, the argument we're having is an argument about the legitimacy of what Lincoln did in the Civil War, which, right, we're celebrating the 150th anniversary of the beginning of the Civil War this year. And Lincoln took many of the steps that were taken 150 years, or I guess 145 years later. Lincoln is the one who really introduced this idea of detaining members of the enemy without considering them to be criminals, right? Even though every member of the Confederacy we captured was an American citizen, and Lincoln considered them as such, right? It's Lincoln that actually introduced the broad use of military commissions to try people who committed war crimes who were captured in the battlefield. It was Lincoln is the one who, again, I'd say, who started to use force right after the firing of Fort Sumter without calling Congress into session and getting their permission, and so on. So I would think that a future president, if they're faced with that kind of problem again, I don't see an insurrection happening unless Rick Perry loses the presidency, though. So I assume Texas will still be part of the Union and won't try to secede. I can't see this happening in our lifetimes, but if it should ever happen again, I think a president could act as Lincoln did. But I think that creates a lot of problems for the way Alberto wants to read the Constitution, because it seems to be, why didn't Congress get to decide all those questions that Lincoln decided as president during the Civil War?
Final comment. I think John overreads much of what Lincoln did into his model. Lincoln was in a true emergency situation in which, during months of his presidency early on, he could not call Congress into session, as I explained earlier. And once he could, he actually sought congressional authorization, and Congress gave him the authorities to do all the things that he did. The military commissions that were created were commissions that were intended to still afford some minimal procedural guarantees, much ampler than the ones that the Bush administration early on offered the Guantanamo detainees, in fairness. Okay? Thirdly, Lincoln also, he pushed on the issue of habeas corpus. Okay? And again, Congress eventually stepped in and authorized much of what he did. But after Lincoln was dead, it turned out that some of the actions of the Lincoln administration were declared illegal by the Supreme Court. Okay? So the Supreme Court held that if a part of the country had federal courts that were open, okay, defendants had to be tried under federal court. They could not be simply tried by the military. Civilians had to be tried federal court if those courts were open. So Lincoln pushed those bounds, but I would not make Lincoln into a lawless dictator. What he did was early on required by the necessity of the moment, but he did try to get congressional authorization, and he got it eventually when there was a Congress that was not interested in breaking the Union apart. And finally, I would say that there are these two authorities that the president has. He is the commander-in-chief of the armed forces of the United States, and he's also the chief executive, and that is known as the vesting clause. Okay, Article 2, the executive power shall be vested in a president. I would just ask you to be careful not to read the vesting clause as giving the president authority to do anything and everything. Okay? Yes, he has a great deal of executive power under the vesting clause, but he is still subject to the law. And we could argue on particular pieces of legislation. As John said, not every statute passed by Congress is constitutional. But the vesting clause cannot allow the president to do anything in the name of his powers as chief executive. There have to be some bounds, and some of those bounds have to come from laws passed by Congress.
I want to just finish up by saying how grateful I am for the opportunity to have been part of this. Thank you so much. And also thank Jack Miller, the Federalist and American Constitution Societies, Jim Dunlop, the Pritzker Library, two absolutely terrific debaters, and obviously everybody here for taking time out in the middle of the week and missing whatever reality shows, Project Runway, whatever is on tonight. And finally, for a guy who couldn't be here but clearly was inspiration in many ways for this, Thucydides. Without him, Lord knows how boring the conversation would have been in and around the treadmills at that San Antonio hotel. Anyway, thanks everybody so much, and have a safe trip home. Thank you.
That was great.
It was a lot of fun.
Let's do it again.
Let's do it again. Yeah, we should do a lot of fun.